Yep, County Court at law number 2 is now in session. The court is in session in cause number M329210. Case of South State of Texas versus Cody Dondre Stelly. Mr. Stelly, is that your full name? How you doing, Mr. Stelly? You doing fine? Now, Mr. Stelly, you were in court on May 2nd, 2023 at that time. You signed the documents titled Judge's Explanation of Rights to Defendants Without an Attorney. And you stated that you would like to have your case at that time reset to hire your own attorney. Have you hired your attorney?
No, sir. My job in the middle of all it. I lost like 3 weeks ago.
Okay, so you lost your job. Now, you understand that as a defendant in a criminal case, you have 3 options. Number 1, you may hire an attorney. Do you understand that option? Number 2, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Do you understand that option? And number 3, you may waive your right to have an attorney represent yourself. Do you understand that option? Now, you're currently unemployed. Is that correct? So you're unable to hire an attorney. Is that correct?
I was working last time I came.
Right, but I'm talking about currently. You are not working.
No, sir.
And do you have the funds to hire an attorney?
No, I mean personally, but
So you still want to try to hire an attorney?
yes, sir. Now that you mentioned that, I'm trying to reach Mr. Rife Scott Kilmer.
Right.
It's hard to get in touch with him.
Okay,
That's who I got used to in the past.
okay. So you want to try to hire Mr. Kimler?
Yes, sir.
Okay. So what we're going to do, we're going to reset your case to give you time to hire Mr. Kimler.
No,
She may be able to give it to you. Mr. Stelly, just have a seat at that first chair by the wall. And then when the court coordinator is ready, she's going to call you up to a window and give you the information that you need and give you your reset. Once you get your reset, you'll be free to go and you have a blessed day. Okay, ladies and gentlemen, I'd like to welcome you to County Court at Law number 2. This morning, we have 3 dockets. We have a trial docket, we have an announcement docket, and we have a motion to revoke probation docket. The just in a few, well, when you came into the door, you was handed out some forms by some folks from Spindletop. Spindletop is our local mental health organization in, I guess, this region of Texas. And they're going to come to you and tell you a little bit about the program that they have to offer at Spindletop. Now, we have Chris and we have Deputy Hinton. They're going to come forward and tell you a little bit about the program that they have to offer.
Thank you.
Okay, you're welcome.
Good morning. My name is Steve Hinton. I'm a licensed mental health deputy by the state of Texas. My coworker, Chris. Chris is a qualified mental health professional in Spindletop. The reason we are here this morning is because the judge cares about every single person who comes before the bench. What the judge found is those who have legal issues commonly have mental health needs, sometimes substance use disorders, and sometimes just a lack of community resources. The judge believes if he can help you with these underlying issues, he can get you out of the cycle of arrest.
So whenever he says mental health needs, he's talking about anxiety, depression, things that everybody experiences at some point and that happens in our day-to-day lives, but the court process does not necessarily make these easier. We have a lot of really great resources in this area or in Texas in general that are well funded, but they're not well advertised. And if you're dealing with any other stress or any other mental issue at the time, it's a little hard to juggle. So even if it's not for you, if it's for a family member, it's difficult to get these things set up whenever you are dealing with everything else at once. So that's kind of when we step in as a giant loophole. We're able to work with them and help you get those set up. Nothing that will get you set up with will cost you things that are going to be state funded, sliding fee scale, working with us will not cost anything. It just allows us to kind of step in and take a little bit of the load off your shoulders.
Maybe this is your first time to be here. Maybe it is your 20th time to be here. There's still hope. This program actually has the ability to change your life, but we're going to need something from you. We're going to need you to share that need with us on the document that was provided, and Chris is going to explain that to you.
So what we handed out whenever you guys came in is a baseline HIPAA consent form. The reason this is made the way it is because your information is protected under the same state law as the medical information. It will not be shared outside of information, and the only thing this allows you to do is contact you and the editor choosing. If you, and the only person who will be contacting with me is me. It's not going to be a robocall situation. So if you reach back out to me, if you continue contacting me, we will continue working with you because we know you work hard for yourself. Everybody here already showed up. You already made the effort to be here in court today. So we're kind of for a loophole. We want to make sure that they, whatever outside stresses in your life, that we're meeting that in the moment as well. We want to make sure that we're here to help.
Our goal today is to advocate for you, whatever that looks like, whatever situation you find yourself into. But also, we want to give you a flyer before you leave here today. It tells you a little bit about the advantages of the program. But on the front is also a 1-800 number. Should you ever find yourself in an unsafe place, you can call the number if you'd like to meet.
So what's important about that number is it is almost statewide. You recognize a lot of people end up in court in Jefferson County that may not be from anywhere close to this area. That doesn't limit our ability to work with you. If you have something you need, you can try and reach out in your area and see what you can find. But it's just about what you communicate with us, what you tell us. The information on that document, the only reason it's there is to identify what resources we can kind of prep ahead of you.
When court proceeds, we will be out here in the gallery. We'll be here in the courtroom. Just get our attention. We'll be glad to visit with you one-on-one, talk to you. We don't want to interrupt the court or delay anything because we understand everyone's time is important. So we'll be here for you if you need us. Let us know. Thank you.
Anybody already has theirs filled out, I can come to you and pick it up or answer questions.
Thank you.
Thank you, Your Honor.
Okay, you're welcome. It's Kimball.
Oh,
Mr. Kimball, would you please put your mic on mute?
On mute? How do I? Okay, hold on.
Thank you. Next case is cause number M333822, case of style, the state of Texas versus Daisy Sam. Ms. Sam, would you please come forward? Ms. Sam, is your full name Daisy M. Sam?
Yes,
How you doing, Ms. Sam?
I'm okay.
That's good. Excuse me. Ms. Sam, you're represented in your case by your attorney, David Grove, who's appearing via Zoom. Mr. Grove, how are you doing? Mr. Grove, how are you doing? Mr. Grove. He has audio. Shows that his audio is on. Mr. Grove, can you hear me? Mr. Grove, can you hear me?
Yes, I hear you.
Okay, you're kind of breaking up a little bit. Mr. Grove, I have before me Miss Daisy Sam. And Mr. Grove, what is your announcement in Miss Sam's case? I can put his mic on mute. Yeah, Mr. Grove, you need to take your mic off of mute. Mr. Grove, your mic is on mute. There it is. It's back on mute. Okay. It keeps going. You keep putting it back on mute. Mr. Grove, could you, it's off of mute now. Now it's back on mute. Miss- It's back on mute. It's off now. Mr. Grove, can you hear me? Mr. Grove, what is your announcement?
I'm just going.
Yeah.
The judge,
Okay. You got his number? Mr. Grove, we're gonna, why don't you call the court?
sir. Hey,
Yeah, you're breaking up, Mr. Grove. Mr. Grove,
sir.
okay, what is your announcement in Miss Sam's case?
Now, another announcement.
Okay.
This is David Grove.
Okay.
Good. I can't through.
On Zoom.
He's on the phone.
It doesn't, I don't think it's gonna mess with it. Mr. Grove,
Mr. Grove?
Yes, ma'am.
okay, how are you doing, Mr. Grove?
Good, Judge. Sorry for all the problems.
Okay, now, Mr. Grove, what is your announcement in Miss Daisy Sam's case?
I have not obtained the videos to review, so I'd like to reset, put our announcement off until we review the video.
Okay, how much time do you need?
I'd say probably, 2 months.
Okay, give me one quick day. Just hold on a minute.
August 6th.
Okay,
September 6th.
September. Mr. Grove, this case is gonna be reset for announcement on September 6th, 2023. Your reset will be sent to you. And Ms. Sam, you're gonna get your reset here in court. Once you get your reset from our court coordinator, you'll be free to go and stay in contact with your attorney and your boundary. Please have a seat at the chair by the wall, the first chair.
I don't have one.
Okay. All right. And
Thank you, Judge. My experience.
yes, you are. All right, you have a blessed day.
Thank you.
Next case is cause number M334208, case of South State of Texas versus Kenneth L. Dean. Mr. Dean, would you please come forward? Okay, Mr. Dean, the last time you was in court, was that April 25th of 2023?
Yes, sir.
At that time, you signed a document titled Judge's Explanation of Rights to Defendants Without Attorney. And you initialed on the line that stated that you wanted to have this case reset
Yes, sir.
to hire your own attorney. Have you hired your attorney? Why haven't you hired an attorney?
So I've been out of work with health issues. I'm just not getting back there.
Okay, now, are you still out of work?
No, sir. I went back Thursday. Last Thursday.
Okay, so you went back to work.
Yes, sir.
Now, do you still want to hire an attorney?
Yes, sir.
Okay. Now, what we're going to do, well, first of all, we just like to say that we're happy to see that you made a recovery
Yes.
from your health problems. And next, your case is going to be reset to give you time to hire an attorney. I know you said you just started back work.
Yes, sir.
So how much time do you need to hire your attorney?
I've been calling one. I talked to him, and he told me the prices. So we just got to get the money.
How long do you think it's going to take?
About a month or two.
Okay. Give him about 60 days.
September 6th.
Okay, we're going to reset. That's enough time.
Yes, sir.
We're going to reset this case to September 6th to give you an opportunity to hire your own attorney. You're going to stand, well, have a seat in that first chair by the wall.
Yes, sir.
All right. Next two cases are cause number M331970 and cause number M331972. Both cases are styled the state of Texas versus Brant Allen DeWitt. Mr. DeWitt, would you please come forward? Let's see. Oh, here we go. That door is locked, sir. You got to go through the other door.
Mr. Dean.
Mr. DeWitt, your full name is Brant Allen DeWitt.
Yes, Your Honor.
How you doing, Mr. DeWitt?
I'm okay.
That's good. Now, Mr. DeWitt, last time you were here in court was on April 25th of 2023. And at that time, you signed a document titled Judge's Explanation of Rights of Defendants Without an Attorney. And you initialed the line and stated that you would like to have your case reset to hire your own attorney. Have you hired your attorney?
No, sir.
Why haven't you hired your attorney?
I don't have the money.
Okay, now, as a defendant in a criminal case, you have three options. Number one, you may hire your own attorney. Number two, if you do not have enough money to hire an attorney, your case, you can request that an attorney be appointed to represent you. Or number three, you may waive your right to an attorney and represent yourself. So since you are unable to hire an attorney, what do you want to do?
I would like a court appointed, please.
Okay, just have a seat back where you're sitting. We're going to give you a copy of the,
Sorry, I didn't even walk off.
no. We're gonna give you a copy of the, you got the affidavit on there? And that sheet, right. Get those, so he has a pen? Okay, thanks. You're gonna fill that paperwork out. That's it. Okay, that's dismissed. That's that. Okay, we got Rodriguez. Who else we have? Oh, Mr. Burbank.
Yeah. That's what.
Okay, we have Mr. Rojas on the Zoom. Mr. Let's see, Brittany Maxon. Mr. Burbank. We have Brittany Maxon. Would you come forward? Is that a motion to withdraw? It is. Give me a copy of that motion. Hey. Hold on a minute.
I don't know, I don't have any information other than his name and he's here.
Did you, okay, this is cause number M3319447, case of style of state of Texas versus Brittany Maxon. Miss Maxon, your full name is Brittany Maxon?
Yes, sir.
How you doing, Miss Maxon? That's good, Miss Maxon. You represented in this case by your attorney Thomas Burbank. Attorney Burbank, how are you doing? State is represented in this case by Attorney Colby Hallpower. Attorney Hallpower, how are you doing?
Good.
Now, Ms. Maxon, I have before me a document that is titled Motion to Withdraw as Counsel. Have you received a copy of this document? The attorney is asking to withdraw from your case. Let me do this here. Have you talked to your attorney about him withdrawing from your case? Okay, let me get this to you. And
I had no conversation with her judge.
all right, just have a seat. I'm gonna give you opportunity to review that document, and then we're gonna ask you to come back up. All right, you can just have a seat. Enoch Briones. Mr. Briones, this is cause number M334074, case of style of state of Texas versus Enoch Briones. Mr. Briones, is that your full name? How are you doing, Mr. Briones? You can come on up closer. Now, how are you doing? That's good. Now, Mr. Briones, you're representing your case by your attorney Charles Rojas, who is appearing via Zoom. Attorney Rojas, how are you doing?
Doing well, Judge.
That's good. Mr. Rojas, what is your announcement in Mr. Briones' case?
Judge, if I can get another announcement docket, I have all the discovery in the video. I need to go over the video with Mr. Briones.
Does he have, bond conditions in this case? Hold on a minute. Okay. He doesn't? Now, Mr. Rojas, I'm gonna give your client some bond conditions. He has a DWI second. Now, Mr. Briones, just I'm gonna hand this to you. And then now, Mr. Briones, you've just been handed a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yes, Judge.
Okay, I'm going to go over this document with you, and it reads as follows. Following the arrest and or accusation in County Court at Law Number 2, Jefferson County, Texas, all bail bonds executed for release of any defendant named herein or orders subject to the following additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, Judge.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, Judge.
Now, condition number 3 does not apply. However, condition number 4 does apply because you're charged with a DWI second, which is a subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code. And condition number 4 reads as follows. A defendant who has been arrested or accused of any subsequent offense listed under section 4904 through 4906 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before the 10th day after today. Do you understand that condition?
Yes, Judge.
Now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. Do you understand?
Yes, Judge. I understand.
Okay. Now, Ms. Segura, could you give us a reset date?
September 6th.
Okay. Mr. Rojas, is that a good date for you?
Yes, sir.
Okay, this case will be reset for September 6th for announcement. Mr. Rojas, you're free to go and you have a blessed day. And Mr. Briones, just have a seat in that first chair and you'll get your reset and a signed copy of these bond conditions. Okay, you're free to go, Mr. Rojas, and you have a blessed day.
Thank you, Judge. You too.
Thank you. Ms. Maxon, are you finished reading that document? You please come forward. Now, Ms. Maxon, did you read the document that is titled Motion to Withdraw as Counsel that was filed by your attorney, Thomas Burbank? Did you understand everything that you read? Do you have any objections to Mr. Mr. Tom Burbank withdrawing as your attorney? Okay. Now, Mr. Burbank, I'm going to grant your motion to withdraw. And you're relieved of any responsibilities you have in this case. Now, okay, now, Ms. Maxon, as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Do you understand that option? Yes. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Do you understand that option? Yes. And number three, you may represent yourself. Do you understand that option? Yes. Now, what do you want to do? You want to hire an attorney? Yes. Okay, so Ms. Maxon, your case is going to be reset to give you an opportunity to hire your attorney. Please have a seat in that first chair. And then when the court coordinator is ready to give you your reset, you'll go up to her window, get your reset, and you'll be free to go. And you have a blessed day. Okay. You could go on the record on this one. This is the one that. Okay, court is in session and calls number M 3336666, case is style of state of Texas versus Christopher William Kelly. Mr. Kelly, is that your full name? Where's- Oh,
Joshua Honey.
I thought y'all was,
Add-on.
oh, y'all, you just mentioned the add-on?
Yeah, it was the add-on.
Oh, I thought you was doing the Kelly. Okay.
No, that's fine.
Oh, okay.
The add-on, we got
Okay, this is cause number M 332-916, case is style of state of Texas versus Joshua Hunt. Mr. Hunt, how are you doing?
All right.
That's good. Now, Mr. Hunt, the state has just informed me that they will be dismissing your case, and is that correct, state?
That's correct, Judge.
And
Mr. Hunt received 5 years out of the CDC criminal district court in exchange for that state of dismiss.
And Mr. Hunt, I'm signing the dismissal. Did he have an attorney? He didn't have an
He
attorney.
didn't have.
Okay. Okay, now, Mr. Hunt, I'm signing the dismissal. You'll be able to get a copy. Well, this dismissal is going to be sent back to the jail with you. All right, so this will conclude your case. I've just signed the dismissal and you have a blessed day. Please follow it up, Baylor. Thought that was done. Okay, Mr. Bless you. Next case is cause numbers M 331-970 and cause number M 331-972. Both cases are style of state of Texas versus Brandon Allen DeWitt. Mr. DeWitt, could you please come forward? Mr. DeWitt, is your full name Brandon Allen DeWitt? Brant Allen DeWitt?
Yes, Your Honor.
Mr. DeWitt, would you please raise your right hand? Mr. DeWitt, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
I swear.
Okay, Mr. DeWitt, you may put your hand down. Now, Mr. DeWitt, I have two documents before me. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, I just filled it out.
Yes. And is this your signature on the line as titled defendant?
Yes, Your
And
Honor.
are these your initials online stating you'd like to apply for a court appointed attorney?
Yes,
I also have a document that's titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, Your Honor.
And on page 2 of this same document, there is a signature above the line that's titled defendant signature. Is this your signature?
Yes, Your Honor.
Now, Mr. DeWitt, before you sign and initial these documents, did your attorney, did you go over these documents with you? Did you go over these documents?
Did I?
Did you read the documents?
Yes, Your Honor.
And did you understand everything that you read?
Yes, Your Honor.
And is everything in these documents true and correct to the best of your knowledge?
Yes, Your Honor.
Okay, Mr. DeWitt, based on your answers in these documents, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney William Wilkerson. Attorney Wilkerson will be given information about how to contact you. You will also be given information on how to contact Mr. Wilkerson. Our court coordinator will give you that information. Now, once you get that information from our court coordinator, you'll be free to go and you have a blessed day. Now, please have a seat and she'll call you up to the club window. Just gonna go ahead. Did she ever copy of that document that you, to that guy? To that guy? Okay, thank you. Mm. Let me see, this is, you requested a bench trial in this case?
Yes, you have a written form, Judge. You have to do the right.
I don't have a form.
No,
Yeah,
I don't have a phone, but I mean, it's
Gotta
gotta
be
be
in
done.
writing.
It has to be in writing.
Gotta be in writing,
Yeah,
so
prior
I'll write
to-
one out right now.
That's fine, as long as it's done prior to our start.
Oh, let me pull this case up. No, this is Kelly right here. Okay, hold on a minute. Oh, here we go. Okay, here we go. Okay. State, are you ready?
Right.
You gotta put M in front of that.
Huh?
The number, you have to put an M in front of it. That's how it's Odyssey identifies it, yeah.
I know where I am. Mr. Kelly knows where he is.
Because they'll reject it.
Are you a little bit fuzzy around? There you go.
Okay.
All these newfangled things.
Yeah. Okay. This is, no, court is in session and calls number M333-666, case of style, the state of Texas versus Christopher William Kelly. Mr. Kelly is present in court with his attorney. Mr. Kelly, is that your full name? Christopher William Kelly? And Mr. Kelly, how are you doing? Okay, I'm sure you've been worse too, huh? Okay. And Mr. Kelly, you're represented in your case by your attorney, Attorney Thomas Burbank. Attorney Burbank, how are you doing?
Doing fine, Jerry.
Now, state is represented in this case by Attorney Kobe Hallfire. Again, Mr. Hallfire, how are you doing?
Good, thanks.
Now, Mr. Burbank, I have before me a waiver of jury trial. Are you submitting this document to the court? Is that correct?
I am, Your Honor.
Now, Mr. Kelly, there's a signature on this document above the line that is titled defendant. Is this your signature? Now, before you signed this document, did your attorney go over this document with you? And did you read and understand everything in this document? And is everything in this document true and correct to the best of your knowledge? And you're asking the court to allow you to proceed in your case without a jury because you understand you have a right to have a trial by jury. However, you're waiving your right to have a trial by jury. Is that correct?
Yes.
And Mr. Burbank, you have also signed this document?
I have.
And Mr. Hoffbauer, you have also signed this document on behalf of the state of Texas.
That's correct.
All right, the court is going to grant this waiver. State, are you ready to proceed?
Yes, Your
State, you may read the information.
Thank you, Your Honor. Cause number 333-666, the state of Texas versus Christopher William Kelly. Information in the name by the authority of the state of Texas comes now the undersigned assistant criminal district attorney of Jefferson County, Texas. On behalf of the state of Texas and presents into the county court at law of Jefferson County, Texas. That in Jefferson County, Texas, Christopher William Kelly, hereinafter styled the defendant heretofore on or about October 17th, 2022, did then and there intentionally, knowingly, and recklessly cause bodily injury to another, namely Jesse William Thomas, hereinafter styled the complainant by punching victim about the face, and at the time of said assault, complainant was a member of the defendant's household against the peace and dignity of the state, signed by the assistant criminal district attorney, Jefferson County, Texas.
Mr. Kelly, how do you plead?
Not guilty.
Okay. State, would you like to call your first witness?
Yes, Your Honor.
You may call your first witness.
State calls Jesse William Thomas.
Ms. Bailey, would you please go call Jesse William Thomas at the courthouse door?
Jesse William Thomas. Jesse William Thomas. Jesse William Thomas. No response, Your Honor.
Mr. Hoffbauer, you'd like to call another
No,
witness?
Your Honor, before the state rest, we briefly explained to the court, we've tried this district attorney's office tried on multiple occasions, both by physically and by locating him through numbers that we had and cell phone numbers. To locate Mr. Thomas, we were unable to do so. The only information we got about Mr. Thomas was that he had been arrested in Orange County.
Okay. Mr. Burbank, you have a motion?
This time, Your Honor, the defense has a motion, oral motion for instructed verdict of not guilty based on the state's failure to prove their case beyond a reasonable doubt.
That motion will be granted. Mr. Kelly, you have been acquitted of these charges. Just in a few minutes, your attorney will be given a copy of that judgment of acquittal. There it is right there. And you can follow the bailiff and you have a blessed day.
Thank you. Thank you very much.
All right. And you may, I think, Mr. Burbank, I think this is your last case.
That's the last one, Judge.
Okay, you're free to go and you have a blessed day. All right. Thanks, Kim.
Thank you, Madam.
Well, you can come on up. I need to, this is cause number M333640, case of style of state of Texas versus Donovan Foxall. Mr. Foxall, is that your full name?
Donovan DeAndre Foxall.
Okay. Mr. Foxall, how are you doing?
Very well himself.
I'm doing fine. Thanks for asking. Now, Mr. Foxall, I was looking at your file. Your file shows that you signed the judge's explanation of rights to defendants without an attorney on May 2nd of 2023. And at that time, you initialed the line said, I want to waive my right to attorney and represent myself. Is that correct?
That's correct.
And also on that same day, you also signed a waiver of counsel for purposes of entering a guilty plea or proceeding the trial. Is that correct? You signed another document saying that you was waiving your right to an attorney. Well, it says here that I have been advised on May 2nd, 2023 by County Court Law Number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed to me free of charge, understanding my right to counsel appointed to me free of charge. I am not financially able to employ counsel. I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. Is that correct?
Yes,
And I think I kind of remember this. We had asked you to come up to the bench, and I may have given you what is called a forerunner warning. For example, ask you whether or not you ever tried a case before. Remember that? Let me do this. Hold on a minute. Okay, now, Mr. Foxall,
yes, sir.
you've indicated to the court that you would like to represent yourself.
Correct.
Now, in this case, are you requesting a trial by jury in this case?
No, I mean, because I spoke with the guy, he told me he was gonna show a video of me doing God knows what.
Okay. Oh, there must have been, was it,
No, I think, we talked?
oh, was y'all talk?
We spoke, and I said, yeah, it got reset, so he needed to make an appointment with our.
Oh,
Because the thing what it was.
okay, let me do this here before you go any further. You have a right to remain silent. Anything that you say can and will be used against you in a court of law. So we don't need to go into the facts, the case, or your version, or anything in that nature. The only thing we're here for right now is to figure out what you need to do from this standpoint on. It's my understanding from what the prosecutor told me, the last time that y'all talked, you were supposed to schedule an appointment at the DA's office to go and review a video. Is that correct?
We're just and review, but just follow through with our pro se discovery, which is the same thing. I mean, it's
Okay.
like you gotta make an appointment.
What he said is, okay, let me explain this to you. What he's saying is since you're representing yourself, you have a right to see, they have a right to have access to the evidence that they have. That evidence is in the district attorney's office, right?
Okay.
And so their policy is that you would have to set up an appointment with the district attorney's office so that when you go there, they can allow you to have access to the evidence that they have in your case.
Okay.
All right?
Could I ask you something?
Yes.
Okay, so I thought he was supposed to have all that access, like basically.
No, it don't work like that. They don't show me anything.
Or showing it in the court office.
No, they don't show it in the court. I agree. Okay. You have a right to have access to the discovery before you go to trial or make your decision to go to trial. Okay. And so what they're going to do is allow you to set up an appointment and then go, once that appointment is made, you show up for the appointment, they're going to allow you to have access to the evidence. They allow you to see the videos, etc.
What I'm supposed to do, like go up there and ask?
Well, he'll tell you where you,
Just in the court, I mean, this is just how the process, and we don't, we can't do it like you want, I'm not sure what you want to see, but I know the evidence, I understand that, man, but we don't do that in court. You have to go up there, an investigator will show you the video committee and we'll provide you with copies of document Jerry evidence, but we can't give you that, but we can show it, provide it for you, okay? And I can't do it in here in court, that's improper, and that's not our protocol. Protocol is for you to go there.
But last time I spoke with you, when I came to court, you told me you were gonna show me proof.
Well, that's the showing of proof, that's what I meant.
Okay, so how do I go
What?
about to go and get proof? To see the video.
Judge is telling you what you gotta
You're
do.
missing some.
Okay, well, he just told you, you gotta go to our office on third floor.
Okay.
And
so
set
I
up an
take my
appointment.
work again to go up there and make.
no, you can just set up an appointment. I don't know if, I guess there was a miscommunication between you and the DA's office. There must have been some kind of miscommunication.
Yeah, it definitely was.
Okay, now let me do this here. Okay, there's something in law that we say, we call it sidebar comments. That's when somebody make a comment toward the other person. That's not allowed. Okay, so do not make any sidebar comments. Now, if I have to tell you that again, you're gonna be held in contempt of court.
Okay.
And if you're held in contempt of court, we can put you in jail, for up to 6 months. You could be able to fine up to $500. Do you understand?
Yes, sir.
All right. So at this point, only thing we need to do is you need to go upstairs. We're gonna allow you to go upstairs to the district. Now, will he be able to go up there now?
Now, we're open to.
Okay. You'll be able to go up there, make an appointment for whatever date that's convenient for you. Okay. And then we'll reset the case after that date so that when you come back here, you will have already reviewed whatever you needed to review. And then when you come back to court on that day, since you're representing yourself, you'll make an announcement to the court as to what you want to do with your case. All right?
Gotcha.
So if you can go upstairs now, I'm gonna give you time to go up. You know where the district attorney's office is? Okay. The stairs right here in front of this courtroom. There are some stairs, you go up to the 3rd floor. And once you get on the 3rd floor, you're gonna see Jefferson County District Attorney's office. Walk into the lobby, there's a lady sitting behind a glass window. Is that the person he needs to talk to?
Yes.
Okay, that's the person that you need to talk to set up your appointment. Let him know that you're representing, you're representing yourself, and judge in county court at law number 2, and you've talked to the prosecutor, they sent you upstairs to set up an appointment so that you can review the discovery. And so once you do that, once you come back here, let us know what that date is. We're going to give you a date after that date for to come back to court. All right? All right. So once you go upstairs and do that right now, and then when you finish, you just come back.
All right.
All right. Jefferson County Court at Law number 2 is back in session. Court is in session and calls numbers M327006, case of style of the state of Texas versus Kayla Dylan Batten. Is Diane? Okay. Ms. Batten, put your purse on the table. Okay, so that's Kayla Diane Batten. How you doing, Ms. Batten? That's good. Ms. Batten, you're represented in your case by your attorney, Attorney Joel Vasquez, who is appearing via Zoom. Attorney Vasquez, how are you doing?
Well, I'm fine, Your Honor, except I'm at Firestone Tires instead of in court.
Okay. Now, Mr.
You working there or is
Mr. Vasquez, what is your announcement in Ms. Batten's case?
Well, Your Honor, could I ask for a reset? I'm sure I had the notice, but I was not aware I was supposed to be in court this morning.
Okay. Ms.
30
Batten, hold on a minute. Ms. Batten, you had to take off from work.
No, sir, I'm currently not working my patient.
Okay. I was just trying to make it convenient with your schedule.
No, it's whatever works for you.
Okay, give us a reset date.
September 13th.
Okay. This case is going to be reset to September 13th, 2023 for announcement. Mr. Vasquez, your reset will be sent to you. And we hope everything turns out all right with you, with your, I guess, your vehicle problems that you're having. And Ms. Batten, you're going to get your reset here in court. Once you get your reset, you'll be free to go. Thanks for being patient with us. And you have a blessed day. Please have a seat at that first chair.
Judge, thank you so much. I apologize. I apologize to Ms. Batten as well.
Okay, you're free to go and you have a blessed day.
Thank you, Judge.
You're welcome. Court is back in session and calls number M333640. Case is style of state of Texas versus Donovan Foxall. Now, Mr. Foxall, you were sent upstairs to the district attorney's office to schedule an appointment for your discovery. Did they give you a date?
No, they said, they were supposed to be fixed to someone.
me? And the text I just got from my secretary, Judge Keanu Fontenot, was that the defendant went upstairs and said he was told by the judge he needed to watch a video. That's not what he was told. So I explained he sat up there to do an appointment, like we've been
Right.
saying, but he's saying he went up there to watch a video. And they're asking me, well, what that is. That's why we got to follow the protocol.
Right.
So that's what text I just got.
We just sent you upstairs to set an appointment. Once you get that appointment date, you'll go in and watch the video, look at a review to discovery. Once that's over, then once they give you that date, then we're going to give you a date after that date. That's what I said.
It's not this today. You can't do that today.
Okay, I
You gotta
understand.
investigate. So
So what does he need to do
he's
now?
gotta go get a date.
So you need to go upstairs and get a date. For your,
Supposed to get upstairs, go back again.
okay, well, they're saying that you went upstairs saying that you wanted to get a video.
Yeah. Renee was, all they're doing like, what is this? Because that's not how we work. We get this point.
Okay.
Look at that.
Change that now.
See?
Jefferson County Court at law number 2 is now in session. The court is in session. In cause number M333026, case is styled the state of Texas versus Robert Langston Dixon. Mr. Dixon, is that your full name?
Yes, sir.
How you doing, Mr. Dixon? That's good. Mr. Dixon, you're here
I'm
represented
here.
by your attorney Langston Adam, who is appearing via Zoom. Attorney Adams, how are you doing?
Hey, doing well, Judge. I'm here.
Okay, Mr. Adams, what is your announcement in Mr. Dixon's case?
If on that case, if you could give me one more announcement for discovery, I think I'll be good.
Okay,
Robert Dixon, right?
yes. Give us a reset date. Okay, this case is going to be reset September 13th, 2023.
Perfect. We'll be ready.
Will be given an opportunity to get the evidence in your case. Now, Mr. Dixon, you're going to get your reset here in court. Just have a seat in that chair on the end. Once you get your reset, you'll be free to go. Thanks for being patient with us.
Thank you, sir.
And you have a blessed day. You're welcome. Next case is Mr. Mr. Diego Angel Rodriguez.
Right. Now, I think that's a case y'all recently appointed me on Rodriguez. I remember seeing him across my desk.
Well,
That's an MTRP.
it was appointed in February. Excuse me, April. In February.
That's an MTRP.
Okay.
Hey, I'm
Hold on.
sorry. I apologize.
Cause number M326366, case of style of the state of Texas versus Diego Angel Rodriguez. Mr. Rodriguez, is that your full name? How you doing, Mr. Rodriguez? You doing okay? Now, this is the motion to revoke probation. You're represented in this case by your attorney, Langston Adams. The state is represented by attorney Cooper Hallpower. And here on behalf of the probation office, Mr. Gary Gilliam. State, what is the state's position in this case? This motion?
State's position is revocation, Your Honor. I mean,
Hey,
we're talking to counsel on an offer.
yeah, because I think I sent the email requesting the offer on that case on Rodriguez.
I don't have an email requesting an offer on that.
So you don't have the email requesting offer?
It should be one.
Well,
But-
it should be in one, and being one is two different things, but if you'll talk to me, I'll offer, but it's revocation, it's not to continue probation.
Okay. So what we'll do in the meantime, we'll set it for a hearing. But in the meantime, y'all still can talk and you can give him an offer on the case.
Yes.
Now, I see Mr. Rodriguez is here on some crutches. Like he must have had some time.
Not recently, Judge. This is at every other, I believe, last time we did crutches.
Oh, he was?
Yes. Last
Okay.
year.
Well, the thing is that, I mean, if the state has that confidence that they just want to go forward with a hearing and they're not going to make it, because what it sounds like to me saying is that if he did make an offer, it'd be a jail offer. So we can have a hearing. Let him bring his witnesses.
Okay, how much time?
Well, Judge, my witness is here, but Mr. Adams said I could have it today. Because
Oh, well.
my witness. Right
Well, but I think you have, it wasn't set for a hearing.
No, it wasn't.
was it?
But if,
No, that's what I'm saying. So he can have his witness. We'll have a hearing.
Yeah, give us a reset date because we'll have to have a court reporter on that date as well. And normally we'll put it on a Friday.
That's fine.
Yeah, that's fine.
Yeah, when we have not a Friday. Well, yeah, it'll probably be on a Wednesday.
August 2nd.
What
Hold
about?
on before you. Let me
Okay.
go look at my calendar. Hold on.
Okay.
August 2nd. Y'all gonna fax me the reset, huh?
Right. It's gonna be sent. Yeah.
Okay, let me go to August the 2nd on my calendar. August the 2nd. Yeah, I'm coming up to y'all on Andre's side, I think. So that should work. I mean, I'm writing it on my calendar now. So this is going to be
It's gonna be a contested hearing.
MTR hearing with witnesses on and this is on Mr. Diego, right?
Diego Angel Rodriguez.
What time?
9 a.m.
No, yeah,
Rodriguez.
we'll probably start the hearing probably about 10.
All right, so county court number 2, MTRP hearing. Now, you want to put 9 or 10 o'clock?
Put 10 on that. We're gonna send you the notice.
Okay, it's on my calendar and I'll be ready to have the hearing with Mr. Hofbrauer. We'll go.
Okay. And Mr. Rodriguez, you're gonna get your reset here in court. Once you get your reset, you'll be free to go. And you have a blessed day. Just have a seat in that chair by the wall. All right, you have a blessed day. And Mr. Adams, I think, now you had another case that was dismissed. They dismissed the motion to revoke probation on Charles Thomas Bell.
Oh, they dismissed bail?
Yeah, he completed everything that he was supposed to do on the probation. I was just telling him about Bell. Okay, so this will conclude the cases that you have in county.
No, and I
court.
have Hillary Samuels. I just appeared. I filed an appearance this morning on her.
Oh, you did?
Uh-huh.
Hillary Samuels? No, Hillary Samuels, she's in jail.
Reverend Jackson is on that.
Okay.
I don't know about that.
Now,
Brevin is in y'all office back now?
Brevin was appointed on that case a few months ago. So you need to file.
Right,
a
I'm
motion
hired.
to substitute. You need to file a motion to substitute.
This brother.
Because he's
Yeah,
already.
because all I did was filed an appearance of counsel.
Okay, so with that case to be reset, give you an opportunity to file your motion to substitute. Okay?
Okay.
All right, so you're free to go and you have a blessed day.
All right. Thank you, Judge. Y'all take it easy. Y'all have a good evening.
All right, same to you.
All right.
Jefferson County Court at Law number 2 is back in session. Court is in session. And cause number M332364. Case is style of state of Texas versus James Anderson Irwin. Mr. Irwin, is that your full name? Mr. Irwin, would you please raise your right hand? Mr. Irwin, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may put your hand down. How are you doing, Mr. Irwin?
So far, so good.
That's good. Mr. Irwin, I have, Mr. Irwin, you're here represented by your attorney, Attorney Alan Parker. And Attorney Parker, how are you doing?
I'm good, Judge, thank you.
Mr. Parker, do you waive a record in Mr. Irwin's case?
We do, Judge.
Mr. Irwin, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Irwin, it alleges that you, James Anderson Irwin, on or about December 25th of 2021, while you were operating a motor vehicle in a public place in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Mr. Irwin, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Irwin, how do you plead? Guilty? Not guilty, no contest.
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Irwin, I also have before me a document that is titled Misdemeanor Plea Admonishment. It is also labeled as State's Exhibit number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials, JE, on the line next to boxes checking no contingent, which means no contest. Did you place your initials on this document?
I did.
On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled
Yes.
Defendant? There are 2 boxes that's checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
I do understand.
The second box that's checked states that you're waiving your right to an appeal, which means you are giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have before me a document that is titled Discovery Certification. Do you recognize this document?
I do.
And is this your signature on the line? It's titled Defendant. Now, Mr. Irwin, before you signed and initial all of these documents that I just showed you, did your attorney, Mr. Parker, go over these documents with you?
Yes, sir.
And did you read and understand everything that he went over?
Yes, sir, I did.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Irwin, are you a citizen of the United States?
I am.
State, I have before me State's Exhibit number 1, the misdemeanor plea admonishment, and State's Exhibit number 2, the probable cause affidavit, which is in the court's file. State, would you like to offer State's Exhibits 1 and 2?
Yes, Your Honor.
No objection.
No objection. State's Exhibits 1 and 2 are admitted. Mr. Parker, you've advised and counseled Mr. Irwin. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Irwin, your attorney, Mr. Parker, has advised and counseled you. Are you satisfied with his representation?
I am.
Has he provided full, effective, and competent legal representation?
He has.
Mr. Irwin, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
In exchange for plea of guilty, no contest, State agreed to recommend 90 days probated for 1 year, Your Honor, $1,000 fine, court costs, 60 hours community-based service, interlock device, and standard terms and conditions if appropriate by probation or DWI. First offense, but with blood alcohol content of 0.15.
Mr. Irvin, the state is offering that you serve 90 days in the Jefferson County Jail. However, you will not be required to serve any time in the Jefferson County Jail on this case because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $1,000 plus court costs of $402. You will also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You will be required to pay a reimbursement fee. You'll also be required to pay the DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you will be required to pay each month while you are on probation, is $211. Will you be able to pay the $211 each month?
Yes, sir.
You'll also be required to perform 60 hours of community service. You'll be required to install an interlock device on any vehicle that you own or operate. You'll be required to have a drug and alcohol assessment, and you'll be required to adhere to the other standard terms and condition of DWI probation. Now, Mr. Irwin, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
I do.
Mr. Irwin, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Irwin, you're going to stand on the X next to your term. I thought you said, did he
It's
say?
80.
It's 80 hours of community service?
Apologize, 80 hours.
Okay.
That was my mistake. 80 hours.
Okay, it's 80 hours of community service. Do you understand that?
Yes, sir.
And do you think that's fair and just?
Do.
And do you accept the state's offer?
I do.
Okay, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Irwin, you're gonna stand on the X next to you, your attorney, follow the directions of our clerk. Once you finish following her directions, you'll be free to go and you have a blessed day.
Thank you.
You're welcome. Jefferson County Court, I love back in session. The court is in session. in cause number M 332-758. Case is filed in the state of Texas versus Raul Antonio Velasquez. Mr. Velasquez, is that your full name?
Yes, it is, Your Honor.
Mr. Velasquez, would you please raise your right hand? Mr. Velasquez, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? So help you God.
I do.
You may put your hand down. How are you doing, Mr. Velasquez?
I'm doing fine.
That's good. Mr. Velasquez, you're here represented by your attorney. Attorney Alan Parker, Attorney Parker, do you waive a record in Mr. Velasquez's
I do.
case? Mr. Velasquez, I have before me a document that was filed by the Jefferson County District Attorney's Office. This document is titled Information. This information alleges that on or about February 26th of 2022, while you were operating a motor vehicle in a public place in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated. Second, this information further alleges that prior to the commission of this offense, that you, Raul Antonio Velasquez, on May 24th, 2010, in County Court at Law number 3 of Jefferson County, Texas, and cause number 282043, that you were convicted of a misdemeanor offense of driving while intoxicated, and that conviction became final prior to the commission of this offense. Is that true or not true? Now, to the offense of DWI second, how do you plead? Guilty, not guilty, or no contest? Now, you're pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Mr. Velasquez also gonna have to, let's check that box.
Okay.
He raised
I'll
that.
recheck.
This is the second, yeah. He's still. All right, thank you. Now, Mr. Velasquez, I have before me a document that is titled Misdemeanor Declared Minors from Slated States Exhibit Number 1. You recognize this document?
Yes, sir.
Now, the box that he checked is still classified as a Class A misdemeanor, it's just that it's a Class A DWI second. Now, and the difference between the range of punishments is with the DWI second, the minimum jail time that a person can get is 30 days, and the maximum is still the same, 365 days, which is 1 year in the county jail. Do you understand that?
Okay.
Now, the fine range is still the same. No, fine cannot exceed $4,000. You understand that? All right. Now, also on page 2 of this document, there's 7 initials on the line that's next to a box that's check no contingent, which means no contest. Did you place your initials on this document? On page 3 of this document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
On the next document, it's titled trial court certification of defendant's right of appeal. Do you recognize this document?
Yes, sir.
And is this your signature on above the line that's titled defendant?
Yes, it is.
At the top of this document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to appeal, which means you're giving up your right to appeal. You understand that statement?
Yes, sir.
I also have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
It is.
Now, Mr. Velasquez, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes, it is.
And did you read it and understand everything that he went over?
Yes, I do.
And is everything in these documents true and correct
Yes.
to the best of your knowledge? Mr. Velasquez, are you a citizen of the United States?
No, I'm not.
You're not? Okay. And Mr. Velasquez, what country are you from?
Nicole.
Nicaragua. Also, they're not on the list. You'd have to sign the top part of the document. You can go over that with him.
Okay. You mean witness it, Judge?
Yes. Thank you. Mr. Velasquez, I have before me a document that is titled for all English for all foreign nationals except those from mandatory notifications countries. And there's a signature on this document. It says printed name and signature. And then there's a box, there's a word that circle says no. And a statement that's above that word that says no is, do you want us to notify your consular officers at this time? It's yes and no, and the word no is circle. Did you circle that? No. And is this your signature on the line where it says signature?
Yes, it is.
And you also, your name is printed. And Mr. Parker, you also witness, is that
Yes,
correct?
Judge.
Now, Mr. Velasquez, before you sign this document, your attorney went over this document with you. You understand everything that he went over?
Yes.
And is everything in this document true and correct to the best of your knowledge? Now, Mr. Velasquez, in the first document, the misdemeanor plea admonishment, there's a statement below a paragraph that is titled citizenship. And that's at the bottom of this document. And the statement states that if you're not a U.S. citizen, a plea of guilty or contingent may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law. Do you understand that statement?
You already asked him if he read it and gone over. all
I know,
that.
I know. But what I'm having to do is,
Well, he,
could you initial that paragraph? I didn't know he was a citizen and wasn't a citizen at the time.
if they've read and gone over all the stuff, I mean, it's just,
Yeah, but
he signed everything,
yeah, but you get
initial there, where it says citizenship when they're here. Sign it.
yeah, but you have people get amnesia, they file rid of habeas corpuses.
You ever have one filed on that?
Yes.
I bet they didn't win.
Yeah, so that's what we have to do this. Okay, now, Mr. Vasquez, do you still want to go forward? Okay, now, Mr. Parker, pursuant to the case of Padilla versus Kentucky, did you explain to your client the consequences of him pleading guilty or no contest regarding him possibly being deported?
He's fully aware of all of that, Judge.
Okay, now, Mr. Vasquez, again, prior to signing and issuing all these documents, your attorney went over these documents with you, right?
Yeah.
And you read everything, you understood everything in these documents. And everything in these documents true and correct to the best of your knowledge. Okay. State, I have before me states exhibits number 1, the misdemeanor plea admonishment, and states is the true to probable cause affidavit. State, would you like to offer states exhibits?
Yes, sir.
Any objections? No objection. States exhibits 1 and 2 are admitted. And Mr. Parker, you've advising counsel, Mr. Velasquez, is there any evidence that he's currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Velasquez, your attorney, Mr. Parker, is advising counsel, are you satisfied with his representation? Has he provided fully effective and competent legal representation? Okay. Mr. Velasquez, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
We do, Your Honor.
And what is that agreement?
In exchange for plea of guilty or no contest, the state recommend 180 days probated for 1 year, $1,000 fine and court costs,
Okay,
80 hours community-based service,
8 hours.
80, 72 hours in jail as a condition of DWI second probation. He's gonna report on June 30th, 2023 before 6 p.m.
June 30th?
That's
Okay.
Friday this week.
Okay.
Interlock device,
Interlock, okay.
DWI intervention prevention.
Interlock. DWI intervention. Okay. Mr. Velasquez, the state is offering that you serve 180 days in Jefferson County Jail. However, this 180 days will be probated for 1 year. During the 1 year probationary period, you'll be required to pay a fine of $1,000 plus court costs. You'll also be required to, now the court cost in this case is $407. You'll also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month, and a reimbursement fee of $15. Let me add that up. Okay. Mr. Velasquez, you also be required to pay up to have a DWI education and initial, pay a DWI education initial evaluation fee of $125 should a further evaluation be needed. You'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation is $211. Will you be able to pay the $211 each month?
Yes.
You will also be required to perform 80 hours of community service, and you will be required to serve 72 hours in the Jefferson County Jail beginning on June 30th, 2023 at or before 6 p.m. You'll be required to install an interlock device on any vehicle that you own or operate. You'll be required to attend and complete a DWI intervention prevention class, and you will also be required to adhere to the other standard terms and conditions of probation. Mr. Velasquez, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, I do.
And do you accept the state's offer?
Yes, sir.
Mr. Velasquez, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Velasquez, you're going to stand on the X next to your attorney, follow the directions of our clerk. Once you finish following her directions, you'll be free to go, and you have a blessed day. Thank you. Court is in session in two cases, cause numbers M330670 and cause number M331584. Both cases are styled the state of Texas versus Ryan Stephen Jackson. Mr. Jackson, was that your full name?
Yes, sir.
How you doing, Mr. Jackson? I'm doing fine, thanks, Jackson. Mr. Jackson, you're representing your case by your attorney Alan Parker. Attorney Parker, what's your announcement in Mr. Jackson's cases?
Your Honor, I've been talking to the prosecutors and I think we're asking for a reset, give them an opportunity to talk to the victim in this case. I think that will help resolve the case.
One regular reset, Judge.
Okay, this is Ryan Jackson on page 5 of the announcement docket, the last two cases.
September 13th.
Okay, this case will be, well, these cases will be reset to September 13th, 2023. Mr. Jackson, your attorney is going to get your recess. Once you get your recess from your attorney, you'll be free to go. You have a blessed day. And Mr. Parker, this is your last two cases. You're free to go as well, and you have a blessed day.
Thank you, Judge.
Okay.
All right. Thank you.
Thanks.
Appreciate it.
Hey, Glenn. Glenn,
What happened to-
I have one real quick.